The fire accident in the residence of a Delhi High Court judge has opened a can of worms, and it is turning out to be one of the biggest scandals in Indian judiciary. To talk about this, I have with me the former judge of the Madras High Court, Mr. Hariparanthaman, in public interest. So thank you so much for talking to us. Before I go across to him, here is a quick reminder. News Minute Tamil and News Laundry. We are a complete ad-free platform. We are not dependent on ads from governments or from political parties or corporates. We are dependent on you. So if you like our work, if you like our the discussions that we bring to the table, do support independent journalism by becoming a member, a paid member of the News Minute and News Laundry. What was your initial reaction when you got to know that there was a fire accident and heaps of cash was found at a residence of a judge of the Delhi High Court?
So, I think everyone will be surprised.
Shocked.
Yes, shocked. It is unparalleled, I may say. Not that there is a corruption in judiciary. It is not my case. Some people think there is no corruption in judiciary. If there is a corruption in the political area, or a minister is a corrupt, or an IAS officer is a corrupt, and a judge also cannot be an exception, is my view. But this is shocking because a heap of currency,
bundles of currency was found.
They used to heap, even more than bundle. It in sacks. And we don't know how it is stored within the premises of a judge's brother. It can't be stored without the knowledge. How can it be? Can a servant, office assistant, or a PA, or we call it a PA, they call it a secretary in Delhi, secretary, or a security guard, can he bring such a huge money? I can understand he can do even a 1 lakh or 2 lakhs. Even
a couple of suitcases may be possible.
But this, unless he is responsible, he has to explain. He has to explain. It is very surprising. It is shocking.
So this appears to be the biggest scandal that
to my knowledge, there were instances where Supreme Court itself initiated action by constituting inquiry committees, and there were occasions motions were moved in Parliament by the members of either Rajya Sabha or Lok Sabha
against
judges. And all those cases, in my view, this is most shocking. And to my, but there is a little bit delay in my view. This happened on 14.
Now that's my question. Like the way the Supreme Court or the CJI has handled this issue, are you satisfied with that? Because like you said, the incident happened on 14th. The news comes out on 21st of March. And after that, the inquiry and other things happen. By then, everything is like, the cash is moved.
Morning it
is gone.
That is a fact.
There's no evidence whatsoever. There are video clippings.
That's all. Video clippings because of police as shown. Now, 14th and 20th, there is a Collegium meeting.
Okay.
20th. Between 14th and 20th, particularly in this era of development and technological development. And it happens within 6 a day, not in a remote place like in Jharkhand. It is in Delhi itself. And of course, he has to get some records. Therefore, he requested the Chief Justice of Delhi High Court to give a report. But even, I think 6 days is a too long a period. And of course, ultimately, now I think something is done. In 20th and 21st, now they have decided to form a committee. That in-house procedure that was devised in 1999 by the Supreme Court. And that they have done that. There are two ways of to take action against a judge for misconduct. One, he is a committee constituted pursuant to a resolution moved in Parliament, in Lok Sabha,
Rajya Sabha.
by the requisite members. Other is the Supreme Court itself is a constituting Chief Justice of India. They are appointing a committee. Here the Chief Justice has appointed a committee to that extent, okay, but still, in my view, it is a fit case for ordering investigation, registration of FIR and ordering investigation into the case by a CBI monitored by a Supreme Court. Because it is I think, really not only entire world is watching. It is shocking, but therefore, FIR has to be registered. But now Chief Justice has said when the Bar Association met, he will take action. And also they said there are many petitions are moved under Article 32 with the same prayer for investigation. But I hope you know, Supreme Court had laid down law in Justice Virasami's case I think in 90s, 91 or so, that no case against a judge can be investigated without the nod of the Chief Justice.
Without the consent of the Chief Justice.
You can suppose here, if a minister has to be investigated, FIR has to be filed. Government, or that is governor is a nod is required. Or if IAS officer, IAS officer, or a DS, government nod is necessary. Even any public servant, the government nod is necessary. Here, it is Chief Justice of India. So far, to my knowledge, I think no FIR is registered, no consent is given for registered FIR, and is it that there is nothing is happening?
But is it a right procedure? Like when there is no FIR, when there is no investigation, the judges have formed the committee. But what happens after that?
The purpose is laudable, sir. One thing. Why, under Article 124, such a procedure is given? A judge cannot be removed simply. A security of tenure is ensured. So that for me, suppose if that Article 124 is not there, I could not have accepted this post. I will freely, I am not bothered. When there is a case came in C.V. Shanmugam's case, I ordered CPI investigation, bringing within the ambit Dr. Ramadas and his son. Later on, after police investigation, they were dropped. But
this was a murder case.
Yes, in the house. How can that at that time they were in alliance with the DMK. DMK was in power for 5 years. 5 years, nothing moved. I am able to. At the time, DMK is in power. But because I am not bothered, no judge can be bothered about anything. Whether it's a government or whoever it is, or any power, because he can't be touched without Parliament passing a impeachment motion. That is the purpose. He is taking oath. Even without fear or favor, he will do justice. He is holding highest post under the Constitution. That is why that security of tenure is good, not only for High Court judges. This given to election commissioner, CAG. Purpose is this. And but
to ensure their independence.
Independence.
Yeah.
But when the occasion is, even Constitution says, when there is a proven misconduct or incapacity, let us not go for incapacity, proven misconduct, impeachment motion will be moved. And the impeachment motion can be moved, but before moving impeachment motion, there should be an inquiry.
Okay.
There's an inquiry by as per the 1999 in-house procedure. Chief Justice appoints 3 judges. Mostly, year before it was 1 Supreme Court judge, 2 others are High Court judges, Chief Justice, another is a senior High Court judges. Whatever it is, there are 3 judges who will inquire into the matter, and it is an independent inquiry where the judge who is accused of misconduct is given a full opportunity. Witness will be examined, documents will be marked, cross-examination is permitted, arguments will be advanced, then they will record a finding. If they record a finding of guilt, then depending on the nature of the guilt, the Chief Justice has to take a decision. And these type of cases, the procedure they adopt is they ask the judge to resign.
So that's all, resignation.
That is a procedure they adopt.
So,
Sir, that is the procedure they adopt. I am telling you the fact.
so there is no FIR, there is no
Sir,
further investigation by any
not
agency.
even removal. He will get a pension.
Okay.
He will get pension. Not even removal. And he resigns. That is what is happening. I am now telling.
So
Suppose a judge refuses to resign, then the Chief Justice will request the President and the Union government to move an impeachment motion in the Parliament.
Okay.
Then it is they have to move because Chief Justice has ordered, because there is a finding of guilt under Article 124 4.
Yeah.
Therefore, you have to do that.
Impeachment motion.
Impeachment motion has to be moved, and 2/3 in both the houses, Rajya Sabha and Lok Sabha, and sitting members, and they have to pass the bill.
So in
motion,
in previous cases, there have been impeachment motions passed in both houses of the parliament.
No, nothing. No motion is passed so far in the independent India.
4 motions were brought.
4 motions, sir.
Yeah,
Yes.
4 motions were brought.
Let us go one by one. 4
Okay.
motions, sir.
So one was
One was
Ramaswamy,
first is
Justice
Ramaswamy. That is before 1989.
okay.
Therefore, it was by Parliament. When the motion was moved in the Lok Sabha, either Rajya Sabha or Lok Sabha, it is Lok Sabha. Then the requirement is under the
MPs have to sign.
has to sign the motion. Then it was accepted by the Speaker, admitted the motion. Then a committee was constituted. 3 judges, I think P.V. Savant was the Supreme Court. There are other 2 judges, maybe 1 judge or one jurist.
Yeah.
And they gave a finding. The misconduct is proved. Charges are proved. The charge against Mr. Ramaswamy is, if I just want to compare this. Now he is no more. Now he died, I think, a month back from Tamil Nadu. And the charge is why he was a Chief Justice in Punjab and Haryana High Court. Earlier he was a judge in Madras. He was elevated to Punjab and Haryana. Later he came to Supreme Court. He did excessive spending to his bungalow and also in purchases, furnitures. That is the basic charge against him. That was found.
That was considered as a misconduct, and impeachment motion
was moved, and impeachment motion was not successful because to that Congress abstained. That was the result, but he was not allotted any work once a committee was constituted. That is by memory. And he retired in 1994 without doing any work. He retired.
And similarly, there are cases of Soumitra Sen.
2 things. Then Soumitra Sen, he belongs to Calcutta High Court. The misconduct is not as a judge he committed.
As an advocate.
As an advocate, he was appointed as a receiver. Certain funds that it has to be deposited in the accounts of for which he is appointed as a receiver. The funds were deposited in his personal account. That was the charge. So some lakhs. Now it maybe 2 or 3 lakhs, maybe 4 lakhs, now maybe 20 lakhs. That was proved in an inquiry. After the proved misconduct, a motion was moved in the Rajya Sabha. In the Rajya Sabha, it was successful. 2/3 passed. Then it should come before Lok Sabha. By that time, he resigned. Therefore, it was dropped.
And P.D. Dinagaran's case, it was land grabbing.
It's a land grab of a government land.
Porambokku
Of barren lands in Tiruvallur district. And for which the same committee was constituted by the Chief Justice of India. They recorded a finding of guilt. And before motion is moved, he resigned.
Okay. So after all this...
and the fourth thing you said about the motion is it was admitted, but no motion, no committee was constituted. He's a Justice Parpiwala from Gujarat High Court in 2015. About more than 50 MPs from Rajya Sabha moved a motion. It is relating to a judgment authored by him. Relating to the Hardik Patel, I think so, about wherein he remarked, that is not related to the merits of the case, he remarked the backwardness of India is due to the corruption and reservation. The reservation part is objected to by MPs. They moved impeachment
So
motion.
he blamed reservations and that
And he
was
said yes, that because why India is backward? Why? Because of reservation. That is what he said in the judgment. When they moved a motion, impeachment motion for this, he deleted that paragraph. Then it was dropped.
Then it was dropped.
Dropped. Nothing.
Okay.
That boat did
So-
not move further.
So the question that a common man has is, like, when judges are involved, when heaps of cash is found at their residence, there's an inquiry committee, and after that, there's no FIR, there's no investigation by any agency, and if they simply resign, they are allowed to go. How is this fair?
I think that we have to introspect what we should do. That is a present situation. Even for that, unless there is the media and everywhere lawyer association, I don't know what could have happened. In-house procedure now, in-house procedure is initiated. I think Chief Justice is deciding as to investigation, and I agree that because by this time such allegation is made against. Take for instance, any minister in any state, even in BJP ruled state.
The first thing that happens is an FIR.
FIR is registered.
Exactly.
If it is in the states like Tamil Nadu or opposition ruled state, apart from FIR, there will be IT raid, ED raid, cabinet raid will continue. Even as a judge, at least there should be a FIR, there should be investigation to find out the truth. How it came. That is why I think this area has to be addressed. There is a lacuna.
And why is that these areas are not addressed so far? Because there have been several cases of judges speaking out of turn, giving controversial judgments.
So that is different. Criminal activity is different from, in my view, this is a criminal. You may, Shekhar Kumar Yadav, he made a hate speech.
Exactly.
For which that is bad thing. But you can't compare it this case. Those things are different. Therefore, for these, there are in-house procedure is for serious offences only. So far, that has taken place. What about other offences? That does not warrant even impeachment. So, first of all, his speech, I don't suggest Shekhar Yadav has to be removed as a judge. But what is that consequence he has faced? Suppose a district collector spoken like that. You could have faced the music. Not even he is concerned. Nothing has happened to Yadav. That is the problem.
So how
That
do
is
we
the problem with Judiciary.
how do we address this issue?
Sir,
Now the entire
sir, I am worried.
now the entire appointment of judges has come under question. People are questioning the Collegium system.
Sir, it is nothing to do with. I think my view is on the Collegium system. Even before Collegium system, the melody existed in my view. Corruption was there. Only thing now there was no media. The issue is, in my view, these problems. They say either before Collegium system or now they say the appointments are made based on the merit. This is the merit. The appointment is not based on the principles of social justice. The majority of the people, that is, scheduled caste, scheduled tribe, OBC, minorities are excluded. Marginalized sections and women are excluded. Now, the law minister, central law minister has announced in parliament yesterday, it is reported. Nearly 80% of judges appointed between 2018 until date in High Court, about 715 judges, about 78 to 80% are from upper caste. 5% SC, ST minorities. 12% is OBC. Then that should be remedied, whether it is a collegium or no collegium. No one speaks about this.
Why there is no discussion about this? That's the whole point.
In fact, there is a discussion, but not in judiciary. Because judiciary is still under the clutches of upper caste. They won't do that. The parliamentary committee has given a report. I think in March, they gave a report to both, there are 31 members parliamentary committee. They gave a report to both Rajya Sabha and Lok Sabha that recommending that they admitting there is a deficit in social diversity in the appointment of the High Court judges and Supreme Court judges. Therefore, they said that the trend in recent times is increased. It is acknowledgement by BJP MPs. They constitute majority. They said the Collegium should recommend. Now they put the blame on the Collegium. They should have said, no, sorry. They should have returned it saying, unless there is a SC judge, unless a ST judge, unless there is a OBC judge, I will not recommend.
So the central government should have done that.
Send that, return back, making it an issue. Let the people will debate. Sir, I will put a small question, sir. With the Yelava community in Kerala is the largest could be. In my view, they constitute around 22 or 23%. Sir, from 1850 to till date, 18 judges were elevated to Supreme Court from Kerala. No one is from Yelava.
Not even one.
Not a. Wait. In my memory, sir, Yelava can become a chief minister. Sir, not one. Not only Pinarayi Vijayan. Not only Achyutanandan. So many chief ministers from Congress were from Yelava community. But
they can't become a Supreme Court judge.
Same thing. To my knowledge, no Yadav. Mulayam Singh Yadav, Akhilesh Yadav will become a chief minister. Lalu Prasad Yadav can become a chief minister. To my knowledge, I don't think. Sir, even if there is one tokenism, how is it correct? Why a particular community occupies a large portion? They constitute 2 to 3 or 5%. These are not only that, not only particular community, are total upper caste and Baniyas. They constitute they take away almost a cake. About that is why Dr. Ambedkar said in the Constitutional Assembly, now we are achieving political justice, giving one vote, one person. All votes are of same value. But in social area, social justice, there is still a discrepancy. We are entering into the life of contradiction. That we have to remove it. He said not removed. It is more and more, it is made complicated. Nothing is done for the first 75 years, either before Collegium or after Collegium.
So nothing has changed before Collegium system, after Collegium. Things remain the same.
Yes, the composition is the same. Sir, how many ST judges are appointed in Supreme Court so far?
And people,
to my knowledge, only one. How many scheduled caste judges? To my knowledge, 5 or 6. Sir, if you take, for instance, for today, not for 75 years, there are 5 or 6. Today, if you take a particular community, they constitute 10 to 12. But that is why OBC did the same thing. But they say they don't have any record about a community because the community is not followed, they only follow merit. Now the parliamentary committee said, no, you now record the community. I don't know. Therefore, everybody is guilty, sir, in my view. Everybody is guilty. Therefore, the solution to be addressed is how to make it easier with the social diversity in the appointment of higher judiciary. That is High Court and Supreme Court.
Inclusiveness. That is absent.
Yes, that is yes. I will repeat it. I like to reiterate it. Scheduled caste, scheduled tribe, OBC, minority, and women. When I ask about Mr. Chandrachud, Chief Justice, you see the district judiciary. Sir, we ask about High Court and Supreme Court. He is answering that. Now, out of, I think, 33 judges are occupying Supreme Court, one less, the sanction string. Only 2 judges.
2 women judges.
Only 2 women judges. Why?
Also, there is one more issue that over the past few years we have been witnessing is particular cases are coming up to particular benches. Convenient benches, and orders are being passed, favorable orders are being passed.
In my view, sir, that is happening from the beginning.
But now it's become...
Maybe because of the social media and awareness.
Yeah, because of the
awareness among people, that is questioned. That is bad. That is bad. That has to be questioned.
No, who will question
that?
that?
Is the fourth.
No, who will question
The
that?
4 judges questioned. The 4 judges of Supreme Court, they questioned it. That the civil society should follow it. Unfortunately, they did not follow it.
But civil society are very scared of contempt of court.
Nothing.
To question about that.
Nothing. What about we can say about what is the 4 judges? Take contempt against 4 judges. Then take me. What we want is that there should be a social diversity appointment, and whenever the cases are were listed, a certain procedure should be followed. Even the master of roster. Now there should be a debate whether it should be the sole discretion of a chief justice or it should be like a collegium. Should
It should be a collective decision.
Collective decision. Yes, and then there will be a collective responsibility. Then these are all the sir. There is a like for instance legislature we admit when now election commission a judgment is passed, immediately a law is brought nullifying that. And if even in bureaucracy or everywhere you see how they act, we know. But as far as judiciary is concerned, nothing is in my view that something more has to be done.
There has to be a cleanup process. There has to be some sort of regulation.
Should be more
Transparency, accountability.
Every appointment we don't know. Only when it is listed, when the appointment comes, when notification comes, you know. Prior to that, there is no process, no discussion.
So, what kind of process is followed?
The process is, sir, if I take for instance the High Court. The High Court, the 1, 2, 3 constitute a Collegium. They recommend certain names from lawyers. As far as district judiciary is concerned, see their mostly, unless they pay some charges, are recommended for High Court judges. The state government view is taken, central government view is taken, IB reports are there. Then the Collegium, consisting of 3 judges, recommends. That recommendation is binding. Now, after the Collegium says it is binding. The central government shall appoint a person. If they have some reservation, they can only ask for any consideration. They cannot refuse.
They cannot refuse or reject or nothing.
They can ask to only reconsider certain names. Then if they on reconsideration, court reiterates, like in the case of John Shatyan, or those cases, or Neelakandan, or they have to be appointed. But the Supreme Court said about the case of John Shatyan, you should appoint with retrospective effect for the first 4 years. It is not done. Supreme Court is not taking any action against the state. Why you are flouting my orders? Suppose if any other agency, any other individual, any other even a big corporate floats order, they should have faced the music. But why nothing is taken? Justice Cowell, before his retirement, the same question came before his bench. But the government pushed out these matters, saying that you are retiring. Thereafter, it is not listed before the bench. Not only in Tamil Nadu, everywhere. So many names that are recommended by the Collegium is not appointed. The names which is convenient, like Victoria Gumni, will be appointed. Like, I don't say even other names. If they don't like a particular name because of John Shatyan, John is the problem, in my view. So Neelakandan is a DMK.
But how is it decided? Like how are these candidates selected?
Selected by by their assessment, sir. That's all. No, nothing. That is a procedure.
The Chief Justice
and two other
judges will sit and assess the names.
Yes, they collect their names. They will recommend their names. Suppose
but who will give them the names?
Sir, they have to collect it. They have to. They
so it's their own wisdom, on their
own wisdom, because before their court they are good and they will consult the other judges. They may consult. Okay. There is no necessity. They consult. They may consult. Suppose there are 65 judges in Madras High Court. You may consult 3-4 judges.
Have you ever been consulted like this?
I was.
When you were there as a judge?
Most not, sir. Maybe. Yes, only. I think on occasion, Justice Bhandamati asked me about some only.
Otherwise, it's their own decision.
They're not, yes, their own decision. They not they consult with the senior in the case. They form their opinion with the lawyer to argue before them. That is a method they follow. They assess, this is a constitutional post. That is not written test. Let us not confuse with that. I am not suggesting you should ask them to clear for an examination.
Like a new or neat examination or
Right,
UPSC.
not like that. You will know the best lawyers, those who have best practice, they don't come accept the assignment because as far as they make a huge money, but here it's a salary. Therefore, I don't advocate, but in the transparent manner, it should be done. A competent person should be selected. Salary completed, and the social diversity should be ensured. That is underlined.
Unless you address all these issues, nothing can happen.
Nothing can happen. It is only then
and judges like Yashwant Verma will go scot free.
Not only Yashwant, so many persons like that. Sekar Kumar Yadav, and about that judge, he retired in Kerala. He's a Chidambaresh. He spoke in the Brahmins, Tamil Brahmins conference against the constitution while he was a sitting judge. He said Brahmins are firstborn because of their good deeds. Then how can he be a judge? I don't understand. He's a sitting judge. These are these are all problems.
And there is no solution to it.
Not immediate. Immediate. That, in my view, the Collegium, abolition of Collegium system is not an answer.
But a lot of people advocate for that. A lot of people say the appointment of judges, there has to be a discussion, there has to be consensus. The judiciary, the bar, the bench, and the executive all should come together and come up with a formula where the appointments are made properly.
Sir, made properly, giving representation to all sections. Do they say anyone? I don't think.
So nobody talks about representation. Nobody talks about inclusion.
Generally, except Tamil Nadu. Except Tamil Nadu or maybe 7 states where the social justice is debated. Nowhere it is taught, sir. For instance,
it's not in the scheme of things.
They are definitely not in the scheme of things. You will be shocked to have the composition. Suppose my experience is in Patna High Court is that is like our Madras High Court. The strength, because I can't compare with Meghalaya, where there is only 3 or 4 judges. That is there where we have that player. We are meeting at the National Judicial Academy periodically. As a judge, I went there from Patna. The grandson of Mandal came. He told me to our shock, all the 2 other persons who came along with me, all the 3 shocked. You asked the only OBC judge. There is no SC/ST judge.
In Bihar.
They see, where is the debate? Therefore, Tamil Nadu is definitely far better in spite of lot of shortcomings. Here, now you see, now there is a big debate is going on. Lawyers are agitating. There should be social diversity. Now it is a large extent it is waiting. Still there is a problem. Particularly after 2014, certain things are happening. That's all.
Certain things are happening.
Certain things means 45. I will make it very clear. I am not for exclusion of anyone's or any community. That is fascism. That is Brahminical. You exclusion. Here, for instance, Brahmins in Tamil Nadu is concerned. If I am not concerned about district judges who are elevated, I am concerned about the lawyers. Now there are about 40 judges from lawyers elevated as a High Court judge. Among the 40 now there are 8 from a Brahmin community. Before 2014, it was 2 to 3. They constitute 2%. It means there will be only 1. 2, 3, 4, okay, sir. Even 5. Now it is 8. Now, when a list is now prepared, there are 10 vacancies. Another 12 vacancies, it arises in this year, 2025. By about the present existing vacancies were 10. There is a belief. 5 names are Brahmins out of 10. That is why there is education in Tamil Nadu. 5 or maybe 4. Sir, already there are 8. They contribute 20%. I think it's a stagnation. They reach at the highest peak level. But here it is 20%. If you go to other state, they contribute 80%. not 20. There is no debate at all. That is what I am saying. Those persons who are saying about transparency, all they nowhere they are asking for, they are requesting or requiring for a social diversity, representation for all community. So they said that even law minister said or Congress said, everyone said, there is no reservation in Article 124 or 217. High Court or Supreme Court in the Constitution. You amend it. But not only that, Supreme Court said in so many judgments, so for higher echelons of service, reservation is not applicable. Is it a reservation meant for the sweepers? But while even the sweeper is not available because you outsource it. These are all the issues in my view. That is the most important, is a social justice issue.
Right, sir. Thank you so much for talking to us and sharing your views on this subject. I'll come back to you if there are more developments in this case. Thank you.
Thank you.